the purpose of the boat was what? One of my favorite things.
Wakeboarding. Well, it's a water
Wakeboarding.
sport. Well, I'm glad it's your favorite thing. That's exciting to know.
I'm not that good at it. I just did it once, but I got up right away and it was super fun.
This is the plaintiff, Maria Kuzmanova. She says she purchased a boat trailer that was made by the defendant and was assured it would carry the weight of her 23-foot boat. When she put her boat on the thing, the axles broke. She wants a refund and is suing for the $10,000 she's owed. This is the defendant, Robert Keel. He says you're not supposed to transport a boat with full tanks of gas. The plaintiff clearly did, which added 3,500 pounds to the boat. That's why the trailer broke. He's accused of being a little too heavy-handed.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
People's Court is now in session. The Honorable Judge Marilyn Milian is now presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Ms. Kuzminova, you purchased a 23-foot Nautic G23 boat and trailer from a dealership, correct?
Correct.
And the purpose of the boat was what? One of my favorite things.
Wakeboarding. Well, it's a water
Wakeboarding.
sport. Well, I'm glad it's your favorite thing. That's exciting to know.
I'm not that good at it. I just did it once, but I got up right away and it was super fun, and I have a friend who's very into it. But so what is it that you do with wakeboarding? Tell me your connection with wakeboarding.
Well, first of all, my son, a 14-year-old kid, he's a professional wakeboard rider, and he competes in national and international competitions. So that was originally the main purpose we purchased the boat for allowing him to train. But besides that, we decided to offer the classes to other people that might be interested in water sports. So we had people coming on the commercial basis to learn from my husband, who is also the professional rider, or from me. And I've been in water sports for over 15 years. So we've been giving classes with the boat.
So this boat and this trailer were used for classes how often? Was it every day?
We would actually use it pretty much on the daily basis.
So what are the problems that you had?
Well, pretty much almost in a month after we started using it, it started falling apart. Well, after we took it to the service, what they explained us that the boat was too heavy for that type of trailer that they had, and they said that the studs and the rims were breaking. The rims had cracks. The hub inside of the wheels, as much as I understand the mechanics, I'm just trying to explain in the basic word. It was leaking the inner grease, making the overheating in the whole system, and the bearings were breaking up. And only 2 months after using the trailer, the first axle broke. This trailer has 2 axles. So the first axle broke and we fixed it. But a month later, we were told that there is a second axle that needs to be replaced as well, because it's also broken. And well, that was the point when I tried to contact the dealership, and they referred me to the defendant, saying that it's under the warranty with him, and if I need to have any repairs, I have to be contacting him directly. And that's when I tried to reach out to him, which was quite unsuccessful. So in 2019 alone, after 2 months of using the trailer, we incurred expenses in over $3,000. with the price of the trailer that less than $10,000. So it was quite a lot. And in 2020, we incurred another expenses for almost $2,500. And that was the point when I reached out to the defendant with the letter, explaining him all the situation, showing him everything that broke, and asking him to get involved in this issue. I received a letter from him with the email of their axle builder. So what he did, he purchased axles from some independent company and advised me to talk to them. So when I reached out to them, and there were like numerous emails between me and this person named Mark, who asked me to wait the boat, and he is saying that the axles that he sold to the builder, to the defendant, were not suitable for that heavy of the boat in the first place. So the axle builder agreed on the fact that the boat wasn't suitable for that way, for his axles.
Let me hear from you, Mr. Keel. Let me hear from you.
Yeah, we built that trailer in 10/17.
Okay, so October of 2017. Go on.
Yeah, and we delivered it to Sun 11/17.
So, and then
And
it
at that
goes
time,
over to
the weight-
them, and they're the ones. I need you to listen. They end up selling it to her. But my question is there a warranty from you on the trailer?
There's not a written warranty that I give to them. I agree to their warranty.
Right, but who gives the warranty to the customer? The dealership or you?
And then I back up Sun.
Okay.
But the axles are warranted by the axle manufacturer, and they carry a 5-year warranty.
Right, but the axle manufacturer is pointing the finger at you and saying that you ordered the wrong axles for this
Well,
truck.
we got a lot of misinformation here.
The boat is a Nautique G23. Okay? This is a Super Air Nautique.
That's what I have,
Yes,
Super
he has a
Air
G-
Nautique
He has a
G23.
G23.
Exactly, that's the one.
Okay. When you told the dealership of your problems, what did they tell you to do?
Contact the builder, because they said it's actually on the trailer itself. It says that the capacity of it is 8,400.
So when they sold you the boat, the dealership told you that it was 8,400 is what it would hold. Then tell me what it is that the axle company revealed to you that was wrong.
Well, they didn't actually mention the exact weight that their axles are supposed to carry. So there was no the number of 8,000 pounds. They just said in basic words, and I can read it off their email.
Here's what I'm trying to understand. What do you think they're saying? I'm not quite understanding. I think what you're saying is, look, this isn't 8,400 pounds, and this trailer should work better than it does. It's breaking apart, and it shouldn't break because I'm not loading it too heavily. Is that what you're saying?
Exactly.
Mr. Kell, let me ask you a question. I realize that you didn't contract with Maria, okay? You contract with the dealership. But obviously, there's a warranty that you give with your products, and so you've been dealing with Maria because it's better to have, you know, you're going to have to deal either with the dealership involved or without the dealership involved. So whatever warranty you've provided, you've been kind of talking to Maria about. What I'm trying to understand then is, have you ever made an effort to look at the boat and see what the problem is?
I offered, yeah.
You
twice.
did. Tell me about that.
We had phone conversations, and she'd never let me have it. She said she couldn't be without it.
Let me ask you a question, Maria. He says that he gave you several opportunities to bring the boat, and so not the trailer, so that he could take a look at it.
It wasn't exactly like that. When defendant was in their dealership while my boat was servicing there, he did offer to take the trailer. But you know what he offered? He said, yes, I can take the trailer, but you have to figure it out what to do with the boat, because I'm not taking trailer with the boat. And I said, okay, do you have a spare trailer? I can put the boat on. Where am I supposed to put the boat? You know, the boat comes with the trailer. And I called the dealer, since they were servicing my boat back then. I asked, can you hold my boat so he can repair my trailer meanwhile? And they said, no, we don't have such an option.
Well, they got a lot of nerve. Let me tell you something. Your dealership has a lot of nerve because they've passed the buck to him completely, and then they tell you that they won't even assist you by holding your boat while the thing that they sold to you gets fixed, because the warranty he gives is to them. So he, technically speaking, you're not supposed to sue him. You're supposed to sue the dealer because you have a contract with the dealer. You see? You have a contract with the dealer. And the dealer is just washing their hands of you, referring you to him. The dealer can then bring him into the deal, into the lawsuit, and say, hey, you warranted me, I warranted her, so you have to get involved. That's how this is supposed to work. Instead, they wash their hands, they tell you to go sue him, go talk to him, and then the one thing they're called upon to do, you want your boat dry docked, and they won't even help with that much. That's unbelievable.
No,
but I don't understand. If you're a trailer builder, Mr. Keel, if you're a trailer builder, why can't, because they've got the lifts that put the boat into the trailer, correct? The dealership has the lifts?
Well, I also have everything to lift the boat. But I didn't want the trailer by itself. I wanted the boat and trailer together because I need the boat and trailer together to weigh everything and check it out and see what caused the problem if there's something else wrong. I have a hard time. She says that you.
Is any of this in writing? Because you guys are just right. You guys are disputing what the conversation was, and none of this is in writing. There's no emails between the two of you.
No, there's nothing.
There's no letters, no certified letters. Yeah, I know. She's out a bunch of money, but look, Maria, what it seems to me like is that you're hustling. You're hustling, you're making money with the boat, and it's easier to just take the trailer while the boat is on the water and you're making money, take the trailer to the marina right there, they fix it, and so you keep putting a Band-Aid on it and putting a Band-Aid on it and putting a Band-Aid on it until in the course of a year and a half, you've racked up some serious bills on a stupid trailer. It's a $10,000 trailer, you have racked up like almost $5,000 or whatever it was in bills. The people who sold you the trailer, those are the people, I don't know how you didn't sue them. You should be suing them too. Okay, now you have a warranty that he is still willing to honor, okay? When you have a warranty, your right is to get the thing fixed. Your right is not to collect money without giving someone an opportunity to fix it. So you have to give him the boat and the trailer for him to fix it. Take the boat over there so that he can honor the warranty. Boat and trailer. I want you to take care and honor this warranty in 1 week. Make this your priority. So there's a warranty, honor the warranty. And now if something goes wrong and he doesn't honor the warranty and he doesn't fix it, let me tell you what you need to do. You need to sue the dealer who sold it to you. You'll see when they're actually in the lawsuit, they will all of a sudden make sure all the right stuff happens instead of washing their hands of you, because they're the ones who give you the warranty. He gives them a warranty. That's a concept in the law called privity of contract. You have a contract with the dealer. You never met this guy before in your life. He doesn't give you a warranty. He warrants them to the dealer. So the dealer, to save a step, he just deals with the customers directly and tries to solve it. That makes sense. So let's try to save that step now, bring the boat and the trailer and take care of it in 1 week. This is her livelihood. She can't be 2 weeks or 3 weeks just in case. She needs you to have it done in 1 week. All right, so good luck, everybody.
Thank you, Anna.
Mr. Keel, what do you think about that? You're willing to cooperate?
Yes, although I've made a real effort to contact her and get a hold of the boat before it festered into this, but she would have nothing to do with it.
Well, of course, she didn't know who you were.
She couldn't be without the boat.
But anyway, you're going to get it fixed for her, and she'll be able to use the boat, change those axles, right? All right, sir. Well, good luck to you. Maria, let me ask you, how do you feel about the outcome of the case now? Are you okay with this? Are you satisfied?
Well, as long as my trailer will be in nice and workable condition, I am. And I'm really hoping for Mr. Curl to take care as urgently as the judge ordered it within a week.
Hope it works out. It's very complicated, but good luck to you.
Let me ask you a question. So you go to Honda and you buy a Honda, and then your Honda breaks down, and Honda tells you, "Oh yeah, I bought the axle from Axelrod Joe over there. So you go deal with him."
Yeah, that's
Not so much.
That's no way to do business.
It's not only no way to do business, it's completely ridiculous. That's not how it works.
It's kind of odd. The dealer kind of told her to.
Oh, it's not odd. It's self-interested. It's kind of, it's very much,
Absolutely.
Obviously it's easier for them. Or frankly, maybe they said, "Okay, we'll work this out," and then they called him, and he's supposed, but they washed their hands of it,
which is really bad.
They really didn't assist in any way, shape, or form.
No.
No, we're not gonna have your boat here. No, we're not gonna help out. No, we're not gonna facilitate the warranty. I mean, they really truly said, "Well, don't talk to us. Go talk to him."
Rodney wants to know this. Hey, Harvey. Why do states have different laws making things so complicated? Why not just have one set of laws for all 50 states? Oh my God, you're asking me a question that takes 3 years of law school. Here's the thing. We have a system in our government where you have a federal government and you have 50 states. It has been that way by design since the framers drafted the Constitution. And the idea is that you have states that may have peculiar needs from one to the next, and you don't want the federal government making one rule where everything it's one size fits all. So I think it's a good thing that states can do this, because then they're accountable not to the whole country but to the people who live in that individual state. And that will do it for this case. Litigants for the next case inside the courtroom.
This is the plaintiff, Lydia Howell. She says her mom lived in an apartment the defendant owned. And when she moved out, the guy didn't return all of the security. Well, in Ohio, the law states if you don't return security within 30 days, you can sue for treble damages. And that's just what she's doing today for the $1,247 her mom is owed. This is the defendant, Aria. He says the plaintiff's mom left a ton of debris in the apartment, and he had to pay to have it removed. The plaintiff thinks he's being unfair because her mother is elderly, but he disagrees and thinks the judge will too. He's accused of not giving a refund.
All parties, please use your right hands.
Welcome back to the People's Court. The plaintiff says the defendant took advantage of her poor elderly mom with a huge rent increase, but the defendant is saying that he's a nice guy, he did nothing wrong, and he thinks the judge will agree.
Have been
Let's
sworn,
find
Your
out.
Honor.
Thank you, Douglas.
You're welcome, ma'am.
Okay, Ms. Howell, you are here to represent your mother, Kathy Hairston, on a lawsuit against the former landlords for a security deposit that was withheld from her. How old is your mom?
She's 77.
Okay. And how long had she been living there?
19 years.
Wow. Okay. What happened?
So my mother lived in a duplex. Everyone loves her on the street. Just lived there happily forever. So in, I believe it was April of 2020, her duplex was purchased by an individual, and Aria assumed, he's with the management company.
All right, so sometime in 2020, the building gets sold, and Mr. Area, you are you the owner? Or are you the property manager? What is your role?
No, ma'am. I am the property manager. I'm not the owner.
Okay. And what happens, Ms. Howell?
So our first experience with Mom's new landlords is in May. They decided to put a new roof on, which was nice. However, it was a nightmare. The contractors that they used were a disaster. They had women, they had dogs, and worst of all, my mother has a flower bed that she's cultivated probably for 19 years. I submitted pictures, and they took all the roofing materials and threw it all around the perimeter of the duplex, right in the flower beds. I had to go over after they were finished and clean up cigarette butts, beer bottles. And so, of course, I contacted Aria. He did an offer to replace the plants that they had damaged. And after the initial complaint, I didn't hear from him again.
Okay.
Then in May or June of 2020, Mom received her rent increase notice.
Okay.
And I believe
How much
the
was your
total
mom paying in rent?
I believe it was around $595.
$595 for what? For a one-bedroom?
It's a 2-bedroom garden. It's a
For a
duplex.
two-bedroom. Okay.
And to be honest with you, I had warned my mother. I said, listen, Mom, you're under market. So, these guys, they buy as an investment. So I want to prepare you for a rent increase. And
Right.
however, close to $300 was just a little bit ridiculous. But
I don't understand. Was your mother in the middle of a lease, or was your mother on a month-to-month? With that kind of rent, she didn't have a lease?
No, she was on a month-to-month.
What did you end up doing?
Well, luckily, if you can believe this, another landlord on the same street heard about her plight, and he actually contacted her. It's actually right across the street, same exact floor plan, same rent.
The lower rent, the one that you wanted to keep.
Correct.
Oh, good for you. That's lovely. But now, so what we're here about is there was a $499 security deposit, correct? And when it came time to move, you were told by Mr. Area, after you moved, you were told, listen, you guys left a lot of stuff behind, and you can either move it or we'll move it, but then I have to withhold money from the security deposit. Tell me how that goes down.
Correct. Here's what happened. I should have looked over the unit more than I did, but we were really rushed and we had to turn the keys in. And I had talked to Area. He said, listen, don't worry about anything. We're going to gut it anyway. And I said, okay. He said, just get everything out. I said, okay, no problem. We left the keys. And then I think it was about 2.5 weeks later, I texted him and I said, I want to know about my mother's security deposit. And he said, well, I've emailed pictures to your sister.
So you sent the sister pictures of what was left behind, and
Correct.
let me see what that was. Okay. Well, none of this, you guys are gutting the place, so I understand there's a lot of stuff left behind. Is that a dresser? Chest of drawers?
Yes, ma'am. With stuff in it.
There's a lot of stuff left behind. Why was all this stuff left behind? Why didn't you take this stuff with you, Ms. Howell?
Well, first of all, I didn't know that it was there.
Okay. I thought you said that you were moving out. I'm sorry, wait. You know that it's, I mean, did you leave somebody else in charge, you mean?
I did. But anyway, when I saw the pictures, he said that the only problem he had was the various stuff left. The only thing big that was left was the dresser, and it was just scattered trash that they didn't take over to the new place. He said the main thing is that I'm going to get a roll-off. I'm going to get a big dumpster, and it's a $250 charge. You could save yourself all that money if you get in, move that stuff, and I'll return the deposit. I then immediately emailed him back and said, that's fine. Just let me know how to get in. My sister and I would have went in that weekend, taken that dresser to the curb because they have bulk service, and clean the rest of that stuff out. It would have taken us maybe an hour or two.
Why didn't you? Right. Okay. So he said if you do that, you'll get the deposit back. Why didn't you guys go that weekend?
Because he never got back with me on how to get into the unit. And that was my whole
Did you respond to her email, Mr. Aria?
I did respond, but I do apologize. I forgot to respond regarding getting access to the property. But I have to tell you, Miss Howe was never shy about contacting me, called me multiple times.
Yeah.
Regarding the roofers, but I forgot to include the information about access, but she never called me back. And all it would have taken was a phone call because there was a lockbox on the door, and I would have happily given that information to her. I just forgot.
Right. So listen, but I don't understand how we get to this lack of communication. The first email is from you to him. Mr. Aria, I have reviewed the pictures you sent to my sister regarding my mother's home. Firstly, the amount of debris left in the home in no way, shape, or form substantiates a $250 dumpster. Fortunately, the magistrates are tenant friendly. See you in court. Okay, that's you at 12:06. His response 50 minutes later is, Ms. Howell, I think the biggest issue is the amount of debris. Unfortunately, these are the charges to get. If you can take it all out, do you think you could do that? Please let me know. Not see you in court for threatening me and making me feel like a louse because I raised the rent to say, okay. So then you write back, that's fine. How do I get in to get the stuff? And then you ask a second question. Also, her 30 days is just about up. Will you bring her check? I guess that was going to be. He responds, The check will be mailed directly from the owner. Please send me your mother's forwarding address ASAP. To which you respond and give your mother's address. Nobody says anything else. Rest of Friday passes. Saturday passes. You're not calling him. It's not like you can't gain entry. Monday happens, and then what happens on Monday, Mr. Area?
So on Monday, we went in to the property and everything was still there. And at that point, we had no choice.
So the question is, what should you be able to keep for the debris that was left behind? I do not agree with her that you didn't answer how I can get in. You left me hanging. That's just not true. You emailed him two questions. He answered one, and then you answered his question, and then both of you just kind of trail off. But it behooves you to say, I need, okay, and how do I get the key you want? Because it's easy. And then you silence, the silence words, and then you're surprised that they're going to keep part of the security deposit, and you're hoping magistrates are tenant-friendly. It's not a matter of being tenant-friendly. Your mother is obviously a beautiful person. I love the fact that she got to live 20 years in one place as a renter. I love the fact that she got to live on the same floor plan for the same reduced rate that nobody gets. That speaks volumes about what a gem your mother must be, that the person across the street wanted to rent. That's lovely, and it's neither here nor there legally. You understand that, right? It's all very, very simple.
I understand that.
Your mother needs to be
Your
treated
Honor.
exactly like any other tenant. You have notice to get your stuff out. You don't need 3 times of the notice. All that stuff needed to be taken out beforehand. So the bottom line is, should they be able to keep $250? If he had kept the $450, you better believe I'd be making him give some money back. Because I know, and he knows, that he was going to be getting a dumpster anyway. So the real question then is, how much should they be able to keep to pull out a couple of dressers and a bunch of junk? For hauling all that stuff out, I think $100 is sufficient. So I am going to order you to return the other $149 to the lovely Ms. Hairston, and I wish you all a lot of luck.
Mr. Aria, you seem like a very decent guy with this. How do you feel about that? The judge making you give back another $149?
Yeah, I'm absolutely okay with that. We try to be as equitable and fair as possible, but the fact is, they weren't as respectful as they should have been. They treated us like we're some kind of crooks, and we're not.
All right, sir. Well, obviously you're going to live with that. Ms. Howell, after looking at all the pictures at how much debris you left there, I'm really surprised you sued for what you did. I mean, it's amazing.
No, the whole contention was he did not allow me to get in and remedy the situation as he said he would. And they are crooks. They're a shiesty company.
Oh, jeez. All right, that's it. All right. Congratulations.
Well, thank you very much.
It's over.
My take on Mr. Aria is he's anything but a crook.
That's right. He couldn't have been nicer.
He was a gentleman in the way he handled this, and it seemed like he kind of bent over backwards.
And she's screaming about suing like early in the day. Don't worry, judges are. I mean, she's
Right.
terrible. I realize she's upset. It's her mother or whatever else. Mother landed on her feet beautifully.
Yeah, thank goodness for that.
But honestly, it's like she's mad at them because they wanted a rent increase, and
Right.
You don't own the place. If you didn't buy it for your mother, you can't get angry as though someone has done something to her.
Right.
It's just not the way it is.
I mean, she's probably saved a lot of money by staying there over
Absolutely.
the years under market,
Yeah,
and
with
that's
the
a good
prior
thing.
owner.
Cheryl wants to know this. Hey, Harvey, how did you start out at the People's Court, and have you worked there since the beginning? Yes, I have worked there since the beginning, and since the show has been on so long, I'm now 114 years old. Actually, the way I got this job, the person who owns the show, Stu Billett, called me up, asked me to go to lunch one day, and he said, I like you. You have a lot of confidence. And then he took me to my car, and I had a flat tire, and I started crying. So maybe he made a mistake. That'll do it for this case. Litigants for the next case inside the courtroom.
This is the plaintiff, Gary Hogue. He says he brought his car to the defendant's shop to get a Bluetooth device installed, and the thing didn't work. That's right, he paid his good money for a working device. The defendant doesn't know what he's doing, and he's suing for the $234.40 he paid the guy. This is the defendant, Jay Speed. He says the plaintiff purchased a USB system for his car, and he installed it. The plaintiff really wanted a Bluetooth device, but how was he supposed to know what his customer's intentions were when he was given a USB device to install? He's accused of not knowing the difference.
All parties, please hit your right hands.
Welcome back to the People's Court. Next case in the docket. The plaintiff says he hired the defendant to install Bluetooth in his car and the damn thing doesn't work. But the defendant says the guy had him install a USB charging device. He did that, and that's it. It's the case of not knowing the
Litigants have been
difference.
sworn, Your Honor.
Thank you, Douglas.
You're welcome.
All right, Mr. Hode, tell me what happened here.
I took my car to have a Bluetooth installed so that I would be able to drive hands-free.
Okay, but what was the
nothing on
reason
the
that you
phone.
brought your car in there to begin with? Because I don't think that, I thought you ran into the device there and thought this would be a good idea. Wasn't there another reason why you were there?
That's correct. I was actually in there to have my windows tinted. And while I was there, I was introduced to the product.
Okay, and how were you introduced to the product?
They had a big display of them in the middle of the room.
Okay, and then did you talk to anybody there about what the product was and what it could do?
I spoke to Jay Speed about it. It was his decision to put that particular device in the car.
Right, but did you tell him what you wanted?
Well, he told me it was a Bluetooth.
Right, but did you say to him, I'd like to use the phone in the following way? I want it to be hands-free, for example, or did you ever tell him what your objective was?
Well, he and I discussed the Bluetooth function, and he provided me with the device to put it in the car.
Okay, and what did you discuss about the Bluetooth function? What was it you said to him you wanted to do? You just said, I want a Bluetooth?
No, I told him I wanted to be able to talk on the phone and drive at the same time legally.
Okay, so then he sells you this device, and the device itself costs $40-something, and the labor to install it was $190-something, correct? So you invest $234.40 in installing this device, and what is the result once the device is installed?
The device did not work. It had no function whatsoever.
Okay. So what did you say? Did you notice that right away?
Oh yeah. When the install job was done, he took me to the car, and he couldn't get it working either. So.
Okay.
So then I asked it to be removed from the vehicle.
All right. And then did you ask for your money back?
Yes, I did.
And what did he say?
He refused.
Okay. Mr. Speed, let me talk to you. What do you say happened?
On Friday, July 24th, Mr. Hode came in to get headlight restoration done on his Chevy Malibu, which he's done a lot of work with us in the past. And upon the headlight restoration, he was in the waiting room, and we have a consignment table that sits in the middle of the room. He was walking around the table and picked this thing up and said, hey, is this, will this work in my vehicle? And I said, well, you already have this unit in your vehicle. And he was talking about a different vehicle that he had, which is his Saturn. So we discussed it, and we never went over whether the fact it was a USB or a Bluetooth. So the function of what he wanted to do with it was never presented.
What does a USB perform? What service does a USB perform?
So USB charges a phone. It makes it so his phone would charge while he was driving,
right. That's all it does. But didn't you? You're the tech guy. He doesn't tell you what he wants, and you don't ask him what he wants. The conversation, what is it you want to achieve, doesn't come up.
The reason it didn't come up was because the Saturn that he has is not. It's an older Saturn. Whether it's in good shape or not good shape, it didn't have the functionality to be able to charge his phone or anything. So whether somebody comes up to me and says, "Hey, I want a Bluetooth or a USB in that older model of a vehicle," then it wasn't for me to ask that question.
Why does he have the impression that what you were installing was a Bluetooth? He had to have gotten it from somewhere.
That may be what he was originally looking for. And then I didn't see him again for another 10 days after he purchased the unit to have it installed in the other car.
But he left for 10 days, and then he comes back in with the unit that you personally sold him and says, I'd like you to install this Bluetooth. If you know it's not a Bluetooth, why are you installing it?
So when it was sold, on the paperwork, it says that he was sold a USB unit. And then when it came back in, we didn't have the unit in hand. It was left in the car. So when we took the car around to the service bay, they just installed what was in the service bay. It wasn't like here, install this Bluetooth unit. It wasn't like a handed over unit. It was left in the car. I had a great
I'm sorry,
relationship
it was
with Mr.
handed
Hogue.
over. It doesn't matter. Someone looked at it at some point and says, this is a USB unit. And
Exactly.
right, and
so that was
before
my
installing it, if they know that the work order says Bluetooth, why don't they stop? First, Mr. Hogue, let me ask you, did you buy the piece and then come back 10 days later to get the piece installed? Is that accurate?
No, ma'am. The vehicle that I installed it in, I charge my phone in that car all the time.
Okay.
So why would I want a device to charge the phone when I already can do it?
Yeah. All right, so let's look at the paperwork in this case. Under the 724 receipt, he is charged for the headlight restoration, I guess, and $43.20, it says USB unit. But then on the day that you come in to install it, on 8/4, it says Bluetooth install. And he's charged $194.40 for that Bluetooth install. So he's obviously getting the idea that it's a Bluetooth from somewhere, and it's on your paperwork. Obviously, he's getting the idea that it's a Bluetooth from you.
Right.
And then, oh, wait, it gets better. Hold on, wait. And then in the uninstall, when he says, take this out, I don't want this, remove BT system. So it's still you guys calling it a Bluetooth over and over. Only one time did someone call it a USB. So even when you're removing it and you know so he's getting the idea that it will be a Bluetooth thing from somewhere.
So I told Gary, I was like, it's not what you wanted. I know that you already have a way to do this stuff. Let me see what I can figure out for you, and let's see what we can do. And he had to go. He had an appointment to get to. So I said, give me a call. We'll figure something out for you. It's not a big deal. We'll take care of it. We'll help you out. And that was the last time I didn't hear from him again. I tried to call him multiple times at the end of that week, and I never got a response. And then the next time I heard from him was the uninstall when I wasn't even here, actually.
He has one goal, and the goal is to be able to use hands-free. And so the fact that you wrote on the first receipt USB is not a notice to him that he won't get what he wants. Then the fact that you write Bluetooth on the install is a further evidence that everybody here knows what he wants. And then the fact that you write remove, you, the collective you, write remove Bluetooth is a third piece of evidence that everybody knows what he wants. I understand that you're out money. Why should he be out money? I mean, you guys are the experts. I disagree with you. I think you owe him his money. I think you owe him his entire money. And I am ruling in favor of the plaintiff in the amount of the $234.40. That's my verdict. Good luck, folks.
Wow.
So the plaintiff is going to get his money back. Mr. Speed, the defendant, it's your own paperwork that kind of did you in. What are you thinking?
That's the thing is she didn't even speak on the whole case. She left out so much stuff. Like there was so much left unsaid and so much that wasn't even gone over. That's crazy.
Mr. Hogue, how do you feel about it? What do you think about what the defendant just said?
From what he says, I have no idea what he's talking about.
All right. Well, good luck to you and congratulations. You prevailed.
This case, like virtually every case you have to decide, comes down to what does the evidence really show? What does the evidence really mean? And in this instance, you interpreted the invoices. You thought they were pretty significant.
Yeah, I mean, they say Bluetooth on 2 out of the 3 working paperwork. So clearly somebody over there is telling him, yeah, this will do what you want. So really, all the way around, it's the standard of proof in a civil case is by a preponderance of the evidence, is it more likely than not?
Right.
And I think he tipped the scales by a mile that, the customer should have been accommodated.
And certainly 2/3 of the evidence, which is more than half, showed that it was supposed to be Bluetooth.
That they themselves were calling it a Bluetooth.
Right. And that ought to carry the day.
Yeah, when you wonder where he got the idea, I think he got the idea from that store.
You know what? And Mr. Speed, if you don't want to pay, get the paperwork right.
Yeah.
So that's going to do it. Folks, gosh, let's be safe. Masks, social distancing, vaccines. Let's get out of this mess. See you next time.